We're going to continue the judicial system now. The first two courts I went over, the municipal court and the Justice of the Peace Court, remember these are all members of the trial court level, but those are considered the local courts. We are now going to move up to the county court at law. This court was also created by the Texas legislature under constitutional authority. So the Texas Constitution gives the legislature to create as many county courts as needed. They have original jurisdiction over Class A and Class B misdemeanors. Now this is where it's going to get a little odd. We talked about original jurisdiction and appellate jurisdiction. And I was saying trial courts have original jurisdiction. They are the court to hear a case for the first time. There's an exception here. And this is the appellate jurisdiction over local courts. Appellate jurisdiction, remember, you're going to check to make sure the legal procedure was followed, the rights of the criminally accused were protected. What occurs is if you are in a trial, how many of y'all ever gone and sat in a county court or a district court, or even watched a court scene on TV? You have the judge, you have the attorneys, then you have that person sitting up there by the judge typing away on their odd little looking machine. This is the stenographer or the court reporter. What they are doing is they are taking they are transcribing shorthand every word said in court. They have their own little shorthand. At the end of the day, they'll go back in their office and they'll type up what was said that day. Well, they are creating the court record. So when you appeal a case, the higher court is going to look at the court record. The county court has a court stenographer, a court reporter. The district court has a court reporter. However, the local courts, so the Justice of the Peace Court and the municipal court, do not have a court reporter. Well, if they don't have somebody to transcribe, to keep this record, to create a court record, how do they appeal? How does the county court know what to look at, know what to see if the proper procedure was followed? They don't. So what will occur is something called a trial de novo, N-O-V-O, trial de novo. And what this means is that if you're appealing from your Class C and you appeal to the county court, you get a brand new trial because they have no records to look at to make sure that you are protected. So it starts all over. Brand new trial. That's how they have appellate jurisdiction over the local court. At the end of fiscal year 2012, we saw 236 county courts at law. There are more than 769,000 cases filed in this fiscal year in all the county courts in Texas. Your judge is in charge of a county court. They are elected to a 4-year term. The highest court, remember we're still at the trial level. We've had the two local courts, we've had the county court. We are now the district court. This is the last court in the trial level. These are all bunched together. The district courts created by Texas legislature under constitutional authority. They have original jurisdiction over all felony criminal cases. They have jurisdiction over divorce cases, cases involving title of land, election contest cases, civil matters, and any matter in which jurisdiction is not placed in another trial court. In densely populated counties, the district courts may specialize in civil, criminal, juvenile, or family law matters. What this means is that when we go to the bigger counties, Harris, Bear, Dallas, we are going to see courts, district courts, that are dedicated to just one item. From Harris County, we had a civil court building. Then we had another court that was a criminal court building. We had a juvenile court building. We had family law. All of these courts were independent of each other. So these judges would not hear cases under civil law, under criminal law, under juvenile law, or under family law. They were subject specific. A civil judge would only hear civil matters. A criminal judge would only hear criminal matters. So in the bigger counties, this is what we have. As of fiscal year 2012, we had 456 district courts. Once again, recall that the state of Texas, the state legislature, can create more, or they can decommission, if you will. They can take away district courts. The district court is considered to be the chief trial court of the state. It handles more cases than, it should not be than the U.S. district courts. In 2012, Texas district courts took on more than 800,000 new cases. Under Texas law, if you're being tried as a juvenile, you're going to be tried in district court, and you're going to be tried in civil law. Very rarely is a juvenile tried in criminal court. This wraps up the courts at the trial level. We're going to move on up to that mid-level, the appellate level. This is the Court of Appeals. There are 14 separate courts of appeals in Texas. The Court of Appeals will hear cases or hear appeals that deal with both civil and criminal law. You're elected as an appeals judge. If you're elected, you serve a 6-year term. Candidates must be at least 35 years of age. To be elected, you must have a minimum of 10 years experience as a lawyer or as a judge. Now, what occurs at the appellate level? There's 14 district courts. 14 appellate courts, not district, 14 appellate courts. And depending on how busy they are, the number of cases they average a year, these courts can have a minimum of 3 people up to a maximum of like 11 or 12. What happens if you appeal a case, the case is argued in front of a 3-judge panel. 3 judges will sit here, they will hear your arguments, they will ask questions. After your argument is over, you have a certain amount of time, usually about an hour, for the plaintiff and for the defense to argue. After your argument is over, the judges will meet, they'll discuss it, and they will publish their opinion a couple of months later. The opinion lets us know who won, what their decision is. Now, where I'm going with this is, in some of the appellate courts, there are more than 3 judges because they're so busy. So what will happen is judges will be assigned to a case by a random drawing. Computer generated, it'll just pick 3 names out of a hat. The problem we have here is that judges also have judicial records. We can see how they have ruled in the past on certain cases. And this can happen at the lower court, at the trial court too. You may file a lawsuit and the case is randomly assigned to a judge. Well, you check this judge's record on how they've ruled, and if they've ruled against you, your type of case, against your type of interest, you simply dismiss your suit, you take your suit out, then you pay the filing fee again, and you have it resubmitted, random drawing again, and you're hoping that you're going to get a judge who is more friendly to your type of case. It's called judge shopping. That's the Court of Appeals. That's the middle level. The highest courts. This is the top level out of those three. The state of Texas passed an amendment in 1891 creating a bifurcated court system. This means that we have a high court to hear civil cases. We have a high court to hear criminal cases. Oklahoma and Texas are the only two states that have this type of court system. I'm going to start off on the criminal side. We have the Court of Criminal Appeals, highest court in the land regarding crime, highest court in Texas. Highest state appellate court in criminal matters. Our judges are selected for 6-year overlapping or staggered terms. That means that first year we'll elect 3, year 2 we'll elect 3, year 4 we'll elect 3, year 6 the first 3 elected, their term is up, we're electing them again. To run for a position on this court, you must be 35 years old. You must be a lawyer or judge from a lower court with 10 years experience. Court of Criminal Appeals continued. The Court of Criminal Appeals has exclusive jurisdiction over automatic appeals and death penalty cases. What this means is a death penalty case, criminal case, it is a felony, so it is tried in district court at the trial level. If the person is convicted at the trial level and they are given the death penalty, they are found guilty and their punishment given is the death penalty, they get an automatic appeal to the Court of Criminal Appeals. The Court of Criminal Appeals has to accept this appeal. This is the only appeal that gets the automatic acceptance. Every other case, the appellate court or the superior court, the high court, has the choice of accepting it or not. Under the death penalty, the appellate court or the Court of Criminal Appeals has to accept the death penalty case. This has occurred since 1976 when the death penalty was started again. Capital punishment was restored in 1976. Since 1976, Texas has executed far more individuals than any other state. Over the last 40 years, we have put over 500 people to death. The next state, I want to say, was Georgia, and they've only executed around 150 people. So the state of Texas uses the death penalty far, far more than any other state does. The Texas Supreme Court. So this is the other half of that bifurcated system. The Texas Supreme Court is the final court of appeals in civil and juvenile cases. The Texas Supreme Court, once again, this is kind of odd. They do have some original jurisdiction, just a little bit. This is over the issuance of writs and conducting proceedings for the involuntary retirement of judges, for the removal of judges. So they do have a tad bit of original jurisdiction. Once again, though, their main purpose in life, they are the appellate court for civil cases. When you think of Texas Supreme Court, I want you to think appellate jurisdiction. To be a judge on the Supreme Court, you must be 35 years of age, a citizen of the United States, resident of Texas, and you needed to be a lawyer or judge of a court of record. So this means county court at law or higher. Remember we were talking about court of record when I was talking about the trial de novo, the new trial. The local courts didn't have the court reporter, so they were not court of records. So you must be a county court at law judge or higher for 10 years before you can run for a position on the Supreme Court. Grand jury. A grand jury is simply a 12-person jury. They meet before the trial. They are there to determine if there is sufficient evidence to try an individual. If 9 of the 12 people say, look, based on the evidence, we need further investigation. I believe a crime may have been committed. They will issue an indictment. This is saying, yes, we believe a crime was committed. We need to have a trial for further investigation. A true bill is an indictment that's already approved by a grand jury. How do you serve on a grand jury? We are seeing a number of courts where you can call the court and talk to the court clerk or the court coordinator and say, I would like to serve on a grand jury. What's the process? What do I have to do? It's a good way to network. You meet people in the criminal justice system. Petit jury, or a trial jury. A jury in a civil or criminal trial. You do not have to have a jury. It is up to the plaintiff or up to the defendant. Most times a defendant will pick to have a jury trial. So your county courts, you have a 6-person jury. Your district courts, you have a 12-person jury. In Texas, criminal courts, for a guilty conviction, the conviction must be unanimous. So all 6 people must say the person's guilty. All 12 people must say the person's guilty. The jury panels are simply selected from the driver's license list. So when you go get your driver's license, you're registering for jury duty. Those courts make up the criminal justice system. The 3 levels, the trial courts, these are the local courts, the municipal and JP court, the county court at law, the district court, the appellate level, one of the 14 court of appeals in Texas, then the highest level of court, the bifurcated system, the Supreme Court, which hears civil cases, the Texas Court of Criminal Appeals, which hears criminal cases. There are 2 other courts I want to discuss with you. First one is simply called a county court, not to be confused with county court at law. Created by the Texas Constitution, each county has a county court. So we have 254 counties in Texas. We have 254 county courts. They have limited jurisdiction. What these do is these courts serve as more an administrative purpose. The county courts are the head of the county government. We have the county judge, and then we have 4 commissioners which sit on county court. Most do not perform any criminal or civil court activities. They decide on budgets, tax rates, that kind of thing. So county court is going to be an administrative court. I put this in the wrong spot. Hold on, let me go to the next one and I'll come back to this one. The other court is the statutory probate court. Once again, created by Texas legislature under constitutional authority. There were 18 probate courts as of fiscal year 2012. Probate courts have original probate jurisdiction. This is going to be exclusive jurisdiction over their county, well, it says in the state's 6 largest metro areas. Statutory probates have original and exclusive jurisdiction over their county's probate matters, guardianship cases, and mental health commitments. What we're talking about here, probate matters. When a person dies and they leave a will, the will needs to go to probate court so it can make sure that the inheritance was distributed evenly. That's probate matters. Guardianship cases going to be regarding children, or it could be adults. Mental health commitments. Are people mentally ill? Do they need to be involuntarily committed to a mental health institution? This is what the probate courts do. It's important to realize, I said in the top six, the six largest metro areas, their probate courts have exclusive jurisdiction over this. Everywhere else in the state of Texas, the Texas legislature gets to assign jurisdiction to what probate matters may be heard by what court. So we may go out to West Texas and probate matters may be handled by a county court, or they may be handled at a county court at law, a statutory probate court, or a district court. These statutory probate courts really only exist in the largest metro areas. Other lower courts can be used in a pinch, in a bind. Now let's get back to where I was. I'm sorry this is out of order. Selection of judges. We've been talking about judges, and I've been telling you age requirements, term lengths. In Texas, we elect our judges in partisan elections. That means that we know if they're a Republican, we know if they're a Democrat. However, for whatever reason, there are often times when a bench will come empty. The judge usually resigned his seat. The judge may have passed. So this means that the governor gets to use his appointment power. They get to appoint a judge, once again with the advice and consent of the Senate. They get to appoint a judge, and the judge finishes out the original term. Then if they want to, they may run for office again. This is what Texas uses. There are some that fear that judges running for election is a conflict of interest, because you'll have a number of attorneys who practice law in front of them donate to their campaign. So some states use the merit plan, which initially, to get their job, the judge has to be appointed by a governor. So a bench comes open. The governor will appoint the judge for his or her first term. After completion of the first term, the judge can run again, but he is now facing a general election. The people get to elect the judge for the second or more term under the merit plan. So in Texas, we can elect first or we can appoint first, but under the merit plan, appointment comes first and then election. Thank you.